So I'll be handing you over, first of all, to Ross Compton, who is the Director of Global Policy for Energeo Alliance. And he'll be delivering a presentation on the work that he does, which will be setting the scene for the widening of the scope of the conversation, with a panel which will then delve more deeply into regulatory context for permitting and consultation. Now, I believe all our housekeeping has been concluded and we're good to go for the next session. Is that the case? In which case, Ross Compton, Director of Global Policy for Energeo, I would like to invite you up to the stage. Please do join me with a round of applause to welcome him up.
Good morning, everybody. Thank you very much for being here this morning, and thank you to AEW for the opportunity. Much appreciated. The intention this morning for this workshop is for me just to provide a very brief overview of Energeo Alliance and what we're intending to talk about this morning, with a little context of the particular topic that we're here for today, so the legislative and regulative context for promoting investment and exploration. Really, the slant is to focus on permitting and consultation. And then we'll move to a panel session of approximately 30 to 40 minutes with the expert panel that I have behind me here today. So I'll introduce those very shortly. Hopefully, a lot of you have got a reasonable awareness of who the Energeo Alliance is, but just in case you don't, we are the trade association for the energy geoscience sector. We've been in existence since 1971, previously known as the International Association of Geophysical Contractors. We are headquartered in Houston, but we work globally, as of course do our members, so we engage with stakeholders all around the world. We have more than 50 companies spaced globally as well, and they are focused on the safe discovery and development and delivery of a wide variety of energy sources, from mainstay sources, including oil and gas, of course, to alternative energy sources and low carbon sources from offshore wind, and an increasing focus on things like carbon storage. Just to focus on our membership very briefly, so the governing members, all the companies on the left-hand side of the screen that you're looking at, are our core members who really direct the approach of the organization. So it is the geophysical acquisition companies, data management companies that you'll be familiar with, so the likes of Viridian, TGS, Shearwater, SLB, and those others listed. Since around 2018, we've had a number of E&P companies among our membership as well, so we currently have 18 E&P companies within our membership, so a lot of the IOCs that you'll be very familiar with, as well as some more regional players as well. So a little context of why we're here today and what we're intending to talk about. So as you'll appreciate, geoscience data and acquisition surveys are very much integral to any kind of energy development, as I touched on, whether that's mainstay oil and gas, whether it's offshore wind, geothermal, all these different sources of energy require geoscience data. And one of the key things is the ability to have access to acquire that data in the first place. And that's increasingly challenging and difficult in different areas, and sometimes for different reasons. One of the key things that we're going to focus on today is the permitting and consultation uncertainties that many companies face. And that's not something necessarily that's specific to Africa. I'm based in the UK. There's plenty of uncertainties there as well. So it's an issue that we face in many parts of the world. One of the key things is backlogs in different parts of the world. So it's not necessarily not having a clear route to a permit, but it's simply capacity issues and the difficulty with sticking to timelines that are really important in terms of driving investment and driving projects forward in different places. One of the key things that I know some of the panel will be able to touch on today is the involvement of multiple agencies. Again, not something that is specific to Africa, but a challenge that we see in a number of areas where there are kind of overlapping areas of jurisdiction between different agencies as you try to progress permits for different types of projects. We'll touch on stakeholder consultation, which in many cases is not certain, has some ambiguities that are challenging to stick to and can be interpreted in different ways by different stakeholders, whether that's people trying to progress a permit or whether that's people that may challenge a permit in different areas as well. And those legal challenges by Energeos, I think, are something that we're acutely aware of in a number of different places, including in South Africa. So we'll be able to touch on those a little bit today as well. So the idea really is to talk a little bit about the background of both the legislative frameworks and the regulatory frameworks that are in place, and touch on some examples within those. Within Energeo, we've spent some time developing what an ideal framework looks like, but it's something that we're doing in collaboration with members at the moment, looking at how we move from the certainty of regular lease rounds to the certainty of how to permit activities within those, for example, and from permitting to streamlining those activities. So not just having a clear route to how a permit is achieved, but really having a streamlined process so you've got some certainty that it can be achieved in a certain timescale that is appropriate to your investment opportunities. Similar with relation to consultation. And then lastly, on environmental restrictions, something that we spend a lot of time on is ensuring that any environmental regulations are both science-based and fact-driven and pragmatic in nature. And specifically, they need to be time-bound so that people have got a good idea of what they're working to and when they can actually move forward with projects, particularly when permits may have a limited life. And coming back to the top of one of these lists now, one of the specific issues that we're looking at is tolling language, so that permits are not necessarily running out of time as there may be legal challenges mounted which put a pause on certain activities. We've developed some consultation guidance in-house, which is really intended to deal with some of these issues and again present an ideal of what we would like from a consultation framework. That doesn't necessarily work in all contexts. Of course, there are legislative and regulatory frameworks in place in different areas that we have to be cognizant of, but nevertheless there is an ideal that provides a certain amount of certainty for members and project proponents as they're moving forward with different kinds of activity. And really we're looking for certainty around timelines, predictability, and an ability to really move things forward without any ambiguities within these particular frameworks. So we have a number of resources. Some of them are public-facing, some of them are not, but we encourage you to take a look at our website and to provide some feedback to both myself and colleagues here in the room today. And we'd be very happy to hear from you, and we can make certain resources available to some of you as well. We also would like to hear from you today on your ideas. So we've posed a Menti question. So if you scan the QR code here, you'll be able to see a multi-choice question, which is asking your perception of what the single biggest above-ground risk to exploration in Africa is. So please take a look at that. We won't be able to show you things live because this is via PowerPoint, not via Menti, but we will be able to, I think, describe the results to you afterwards because we'll be tracking it as the session goes on. So please take a look at that. If the multi-choice question doesn't speak to your particular view of what the greatest risk is, please do follow up with us on email, and we'll likely be sending a brief wrap-up of the session to all attendees as well. So the aim of today's workshop really is to hear from the panel of professionals behind us, which are across a spread of different stakeholders, from regulators to those working in legal defence, those who are operators and so on. So we've really got a good spread of experts here today. So I'd like to introduce our panel of experts before we move on. So hopefully in order, I think, we have Dr. Bongani Sayadini, Chief Operating Officer for the Petroleum Agency of South Africa. Welcome, Bongani. Thank you for being here. We have Sue Reuter, Energy Sector Lead from SLR Consulting, very much involved with the ESIA process on a number of different projects. Welcome, Sue. Immediately behind me, I think, Alice Carroll, Head of Corporate Sustainability from Eco Atlantic Oil and Gas. Welcome, Alice. Jacinta Francisco, Legal and Compliance Manager from Total Energy South Africa. Welcome, Jacinta. And last but not least, to my left here, Megan Rogers, Director, Oil and Gas Sector Lead with Cliff Decker-Hoffmeyer. So welcome all. Thank you very much for being here today. That's it for the presentation. I'll just pop that back on screen for anybody who may need it and take my seat to kick things off. So we have around 30 minutes or so. The intention is for us to go through our panel, and then we will open up briefly for questions from the floor at the very end for anybody who may have anything outstanding that we've not covered. But I'd like to kick off, Bongani, with you, if I may, really, to talk about the role of the Petroleum Agency within South Africa. And what I'm really looking for is how has PASA sought to provide certainty and guidance to explorers within South Africa, and what do you see as the role of the regulator really in not just providing that certainty, but in reaching out to communities to move those projects forward and get buy-in from the communities that we're working within?
Thank you, Ross. Good morning, ladies and gentlemen. As already introduced, my name is Bongani Saidini. I'm the Chief Operating Officer at the Petroleum Agency, SA. We are the regulator of the upstream petroleum sector in South Africa. To conduct oil and gas exploration and production activities in South Africa, companies are granted petroleum rights. These range from a reconnaissance permit, which enables, for example, multi-client data acquisition activities, seismic acquisition, for example, technical cooperation permits, which allow a desktop study over a year, and exploration rights, which run for a 9-year period, starting with an initial exploration period of 3 years that is renewable 3 times, 2 years each time, as well as a production right, which has a 30-year duration. So companies holding a technical cooperation permit have an exclusive right to apply for an exploration right and the subsequent production right. So for potentially intrusive activities or listed activities in terms of the National Environmental Management Act and related environmental impact assessment regulations, activities such as drilling of wells, for example, seismic acquisitions, require an environmental authorization, and embedded in the environmental authorization is based on an environmental impact assessment, and embedded in the environmental impact assessment is public participation. So, so there were court cases, I think 2 seismic acquisitions were interdicted, successfully interdicted in South Africa in late 2021, early 2022. And those, in terms of the judgments, the public participation process was deemed to be inadequate or not meaningful. So so that meant that seismic acquisition by Shell and Impact Africa that was already underway had to be stopped, maybe 10% into the actual acquisition, and so on the basis of those successful interdicts. So what did we do as the Petroleum Agency to try to enable a future activity led by the Minister of Mineral and Petroleum Resources? We visited the affected areas which were along the East Coast, an area called the Wild Coast. The minister led officials of the Petroleum Agency and the department in engaging with local communities. The Eastern Cape covers about, or has about 7 kingdoms led by kings. We visited all 7 kingdoms, and the minister was at each and every one of those engagements over a 6-month period. We also, there was a well that was drilled in October, November by Eco Atlantic offshore the West Coast. This is where another seismic acquisition by Searcher was also halted. We visited the local community just before the well was drilled, again led by the minister. And that well was actually successfully drilled without any interruption or protest by local communities and without any safety incident. So the efforts led by the minister and the Petroleum Agency seems to have, or are beginning to bear fruit, or seems to have worked then and have begun to bear fruit, because we've seen another seismic, successful seismic acquisition that was done by Searcher this year, starting in January and ending in April of this year. So both an offshore well was drilled without any interruption, a seismic acquisition was done this year without any interruption. So that's some of the things we are doing to enable exploration and production in this country.
Thank you, Bongani, much appreciated. Does anybody have any follow-up before I move on at all? So you've touched on some of the cases where projects have been stopped, which is really important, and we're going to come on to lessons learned, I think. But just before we move on, Bongani, you talked a lot about the engagements that you've had, and those have really continued. You've had some quite recently, in fact, as PASA. Have you found those to be particularly impactful in sort of shifting people's opinions in communities?
I'm not quite following the last part, Ross.
You've had some recent engagements as PASA, I think. Yes. Have you found those quite impactful in the communities in terms of shifting people's opinions to these types of projects?
Yes, indeed. I mean, the fact that that well was drilled without any interruption by local communities means our efforts have been successful in getting communities understand, because in the main, the communities didn't have an appreciation of what oil and gas is all about. What are the risks associated with oil and gas? How are such risks mitigated? What are the potential socio-economic impacts, for example? So in that educational campaign, trying to reach out to the communities, we shared all of this information, and communities are increasingly embracing activities. Another case in point, this seismic acquisition that's now gone ahead unhindered. So those engagements are beginning to bear fruit as communities begin to understand more and more about oil and gas.
Thank you, Bongani. So let's move on to talk about some of those lessons learned, perhaps, and some of the ways that which companies are really engaging in those communities, because of course there's what the likes of PASA are doing, there's what companies are required to do as part of their public participation process. Alice, come to you first, if I may, just for some of the lessons learned from your point of view in terms of engaging with those communities on the ground, and whether and how your strategy may have changed over time at all.
Sure, thanks Ross. Good morning everyone, I'm Alice Carroll from Eco Atlantic. Bongani's already kindly mentioned the well that we successfully drilled unchallenged in 2022. Just to go straight into your question about engaging with the communities, I think there's a how and a why. How you engage with the communities and why you're doing it. And that's outside of just being legislated to do so. So lessons we learnt as Eco Atlantic is boots on the ground representation of the applicant, be it the oil company or the seismic company, matters. The communities want to see you and they want to engage with you, not just the EAPs or the environmental specialists. Because, as Bongani quite rightly said, there's a lot of awareness of mining processes. There's a disconnect of how oil and gas as an industry operates. And if you're there as the applicant or representing, you can be upfront, you can be very truthful about the timelines and the employment opportunities and the job creation potential. We actually found that a lot of education was needed to inform the communities on just the life cycle of our industry, going from exploration to development to production, how long that actually takes. And alongside, and this is from my experience in South Africa, there was quite a lot of incorrect, false, misleading, choose the right word, information about E&P processes circulating in these communities that was slightly scaremongering. So our strategy changed. From our first engagements in country, we actually chose to go back, and we had lots of discussions with PASA around this, to go back into the communities voluntarily and have information sharing sessions to explain the industry, but also the ESIA processes. You know, they're huge technical documents. For someone in the local community to suddenly be hit with that, it's a lot of information that needs to be broken down. So I guess our key lesson was direct community contact, local stakeholder relations, to avoid disruption from non-community-based groups, potentially seeking their own gain through community disruption and spreading misinformation.
Yeah, absolutely. Thanks, Alice. And I think that's something that we've been very aware of. And you touched also on I guess, the complexities of the topic. It's not just the life cycle necessarily of the activities from seismic to drilling to production and so on, but the actual activities themselves are very complex as well and not necessarily easy to convey to people. And it's a part of our work as well in providing support to members in terms of what we hope are easily digestible memoranda, if you like, about what a seismic activity, for example, is. And of course, many similar organisations are involved in supporting companies with similar information for drilling and that sort of thing, but it's not easy. Sue, from that sort of ESIA perspective and conveying that information, could you talk a little bit along the same lines of what your experiences are, whether in support of some of the companies who you're supporting with these ESIAs and consultation processes, whether you've had to sort of change your approach or beef up your approach in any way?
Yeah, thank you very much, Ross. I would like to, for starters, echo two of the important points that Alice made, which is the one thing is there is no one-size-fits-all approach. It is very community and project specific, and also that there are different forums for engagement. There is a forum for an inside an ESIA process, which I'm more engaged with as one of the ESIA practitioners, and then there's a forum outside of the EIA process, which can be driven directly by the operator in a non-regulated, non-stipulated manner, and that is often very important too, depending on the context. So it is important to remember that there are different kinds of stakeholders involved, sort of from a community, public stakeholders, let's put it that way, as opposed to financial, and there are many other stakeholders too, involved in these processes, and some of them through an ESIA process we would identify upfront as being potentially affected communities, and they typically receive quite early attention and quite focused attention during a process. But there are also other stakeholders who are interested, and they're equally recognized as stakeholders. They also need to receive information potentially on a slightly different focus, slightly different approach, depending on who they are. So it's important to recognize there are a number of stakeholders, and they may be self-identified, and they will be identified throughout the process from an ESIA perspective. And that determines what kind of formats, timelines, and so on you apply. And coming to the no one-size-fits-all point, especially from a community point, it really depends on what is the prior knowledge. So we have just heard, if there is very little knowledge about the industry and about EIA processes in general, then a lot more in-depth engagement needs to be undertaken. For example, if communities have already been engaged over numerous processes and years potentially, then we might start looking to vary that format and how we engage communities to not bring the same point over and over, but become more project specific, to point out potential differences between projects they might have heard about before, to make that more meaningful and less generic, essentially. And also, it's very important to obviously take into account the community specifics in terms of language, literacy, and so on. So that will also determine whether any audio information is provided rather than just written reports and so on. So there is a lot that needs to be analyzed up front, which is standard practice. You do your stakeholder analysis and mapping, and based on that you build your consultation process to really speak to these stakeholders as best possible.
Thank you, Sue. As I work my way around Jacinta, have you got any sort of similar experiences from the work that Total Energies has been doing in this space and some of the consultations that you've had to be involved with?
Sure, thank you, Ross. Good morning, everyone. I'm Jacinta from Total Energies. So a key value of Total Energies is respect. That means respecting our staff, respecting stakeholders, but it also means respecting the communities, the host communities in which we work. Part of that is really exactly, it's similarly what Sue and my counterparts have mentioned, is that to meet the communities where they are, to understand how to engage with them in the appropriate way, that they will really truly understand what we are about. In addition to that, a key priority is essentially to answer all questions raised by communities honestly and as usefully as possible, so they can use the information that we provide in order to make proper decisions as to how to approach the project, how to engage with Total Energies and the operators and the EEPs. and everyone around.
Thank you, Cynthia.
Thank you.
Megan, not to leave you out, come to you next. We've kind of talked about the issue a little bit, and that of external influences, that of sort of ambiguities in the process that can be exploited as you identify these different groups of stakeholders that should be consulted with and provided relevant information and so on. What do you think has been the influence of some of the environmental NGOs which may or may not be external to a particular jurisdiction, and how do you think that's affected people's ability to adequately engage and really provide people the information that is required of them?
Good morning, ladies and gentlemen. Thank you, Ross, for the question. Megan Rogers from Cliff Decker, my attorneys. I think one of the first things when we saw the emergence of court challenges within the industry from a South African law perspective was that one of the first things my clients asked me is, what is the construct, or the legal construct around meaningful participation? What is a meaningful consultation process? And regrettably, my answer was that it is very much still a philosophical term. What it really aims to achieve is effective two-way communication. That's what it's all about. So we must distinguish this from consent. Meaningful consultation doesn't mean consent of communities or agreement with communities. It means simply that we must engage effectively. And the difficulties with the emergence of environmental NGOs or lobby groups who essentially had anti-oil and gas campaigns is that there was so much misinformation, and the panelists have spoken about this a little bit. There was so much misinformation amongst the communities. It often was alarmist misinformation. So what industry had to do, as well as the regulator had to do, was debunk myths and address the misinformation as the first step to reaching a meaningful consultation or consultative process. And once those myths were debunked and we addressed the misinformation about the impact or the footprint of the upstream oil and gas industry, particularly from a South African perspective, this then paved the way to talking about project-specific impacts. And that's really what meaningful consultation has been in South Africa to date, in order to get to this sort of two-way engagement. And there have been significant steps you would have heard from Sue and from Echo, from Alice and from Jacinta as well as Bongani from a government perspective. There have been significant steps taken by both industry as well as the environmental assessment practitioner groups in order to ensure that we have this effective two-way communication and remove the miscommunication or the misinformation. It ultimately started with proper stakeholder identification. And then it ended with ongoing engagement. So that's what the consultation process looks like in South Africa at the moment. But unfortunately, as you would have heard from the panelists, most of these steps have been proactively taken. And what I mean by that is that there's an absence, or at least there's an absence of a regulatory framework to effectively deal with what communities are calling on as meaningful consultation. So there's a big gap in the legislative framework and in the regulatory framework, and if you'll forgive the phrase, this is essentially where the trouble is created, right? This is where the debates about between NGO groups and industry and government arises. So absent an effective regulatory framework, and again, it's not a one-shoe-fits-all sizes type of framework, but it's a recognition that Eastern Cape communities require a different form of consultation given the leadership structures within those communities from the Western Cape community. We have gathered that knowledge during this time period as industry. And we cannot have a situation in South Africa where our public consultation guidelines haven't caught up with the knowledge that we have today. and ultimately the expectations that the courts have and the communities have around consultations. Most of these charges around getting to meaningful consultation have been led by industry, by the environmental impact practitioners. So there's a clear gap, Ross. There's a need to regulate this space with a more comprehensive playbook, right? And that's going to be a critical step toward the measurement of and bringing certainty around what meaningful consultation is. And ultimately that will have a knock-on impact when it comes to challenges around whether your consultation has been effective or not. You'd have a measuring stick, a yardstick, so to speak, at least a basic rule book as to how these consultations are supposed to unfold. In that way, you ensure that the communities know and understand the playbook, government understands and knows the playbook, and industry understands and knows the playbook, as well as the NGOs. So that's ultimately what is needed as the next step to our evolution around public consultations in South Africa.
Absolutely. Thank you, Megan, for getting to the nub, I guess, of where that gap is. Thank you. Sue, do you have a reaction?
I just thought it might also be worthwhile acknowledging limitations of what consultation can
Sure.
achieve, because these are highly, highly technical topics, very complicated, and we cannot ever expect that we can achieve full understanding of a wide range of specialist topics that specialists with PhDs and so on have drawn up. To really to have a in-depth technical understanding through consultation is a very tall order. And the other aspect that I think is important to acknowledge, that consultation does not mean that everyone is afterwards of one opinion. There will still be different opinions on the matter, and that's a reflection of the larger context of society, and that's acceptable. That does not mean consultation has not been successful. So firstly, technical information conveyance is by nature limited to a certain extent, and yeah, there will be various views which need to be debated and decided on.
Thank you, Sue. So we've had a strong bias, I guess, towards South Africa in this conversation, naturally, given where everybody is from and the fact that we're here. But it'd be good to just sort of compare a little bit around different jurisdictions and different experiences in different places. So with that in mind, Alice, come to you if I may first, please. Just for some examples on the key differences between exploration projects in different jurisdictions, as much as you're able to touch on, and how those differences really impact your decisions when trying to move those projects forward.
Yeah, I think it's straight off the bat, I think it's safe to say frontier exploration is high risk, high reward endeavour. And so to make any decision on projects, you're looking at several metrics. And they have to be assessed all together. There's technical, there's legal, there's your company's strategic rationale, fiscal and regulatory environments, and of course, very relevant to South Africa, the above ground risk. In exploration, it must be a balance of all of these factors for a company to be prepared to take the risk to either enter the country or to drill an exploration well. You touched on it actually in your presentation at the beginning. If African country fiscals actually have never been so stable comparatively to where we're from in the UK. Just to give a bit of perspective, the UK has changed its windfall tax, which is the energy profits levy, 5 times since it was introduced in 2022. So this has completely reduced bank debt, and they've stopped lending because they just don't see the value anymore. So if one metric shifts the balance, it has an impact on whether you invest. That can be positive and negative, particularly in the North Sea, it's negative. But that's where the industry works in an ecosystem, and we've got smaller independents like myself, large IOCs and majors, just into the left of me here, and we work symbiotically because, and it's necessary to do so because our appetite for risks change. Smaller companies can move nimbly, they can approach certain risk factors with a different perspective. The larger you are, the more reputational risk you're perhaps looking at. And you see it, look at, say, the impact oil and gas in Namibia, dare I say it, without an impact oil and gas working Namibia for as long as they did, would there be a Venus discovery right now through Total? And they have to evolve. You know, we're seeing now in Angola, they're amending some of their terms to try and re-attract investment. They've divided up some of their fields. You have to evolve to keep attracting the investment or you get left behind.
Yeah. Thank you, Alice. Jacinta, any experiences you can comment on in this?
I think I just echo a lot of what Alice has mentioned, just about stability in terms of what expectations there are from the regulatory regime and what can be seen, what can be taken into account in making those kinds of decisions. Obviously, reputation is quite important, but also the environment in which you operate, how far off from the coast is it, what are the local communities, what are their expectations, things like that. Thank you.
Thank you. And I guess we've touched on a lot of these themes already and also where the gaps are. But maybe yourselves or perhaps Bongani, if you could kick us off on this, what do you feel are the sort of reassurances that companies are looking for in order to make investments, whether that's around permitting requirements or some of the other factors that we've touched on? What sort of reassurances do you feel that players are looking for?
Thanks, Ross. I guess companies want, fiscal stability in terms of tax, royalties, state participation, for example. Those should not abruptly change, for example, with a change of government. So companies want almost like that, a guarantee that fiscal regime will not change. In South Africa, for example, the exploration rights contain a stability clause which guarantees that the terms at the time that the exploration rights are awarded will not be more stringent in the future. So companies are looking for that fiscal stability. I think in the main, yes.
Thank you. And I think that picks up nicely on Alice's point about the UK, that complete lack of stability that we've seen there across the last 5 years. It's easy to sort of blame a change of government, but actually it had been happening long before. Megan, have you got any comments on this in terms of what sorts of reassurances companies are looking for? I think in our prep you talked about the rule of law basically and upholding that in all of these deals.
So I think Bongani's point is quite important around legal and fiscal stability. So in addition to sort of an investment policy that attracts, and looking at this purely from a government perspective, an investment policy that attracts much needed foreign direct investment. And if you go back as far as 2009, the African Development Bank and African Union said to African countries, you are competitors in attracting foreign direct investment, so make sure that you have a robust legal system. The criticals around fiscal and legal stability is one that governments generally tend to shy away from. There's a great reluctance to offer that. But if you look at the industry and sort of the long investment time, the fact that it's a high-risk capital industry, you need to be competitive from a government perspective. Look at the deals which are being offered by other African countries. There's a big drive towards legal stabilization and fiscal stabilization in a recognition of the nuances associated with the industry. So you must start to be competitive and play with terms which essentially allow the investor the opportunity to know that the investment is secure from not only a legal perspective, but also from a fiscal perspective. And then what you absolutely must not do is destabilize the deal by changing the rules midway the investment. So the rule book and the terms of engagements need to be clear with due regard to the fact we're talking about long-term investments, which ultimately lead to the discovery or are aimed at leading towards the discovery of the resource. And then there must be enforcement of the deal enforcement at a judicial level, enforcement at a government level. And when it comes to resolving disputes resulting or relating to permitting, be it environmental permitting, be it license permitting, there must be recognition of the fact that we're dealing with a time-sensitive industry. Governments, and often the legislative regimes themselves, require that energy companies complete certain work program activities within a certain period of time. So, and this drive comes from, particularly from a South African perspective, South African law perspective. The reason for the drive around getting work program activities completed within a certain period of time is to avoid sterilization of the resource. So within that context, when you're dealing with things like appeals against environmental or other permitting process or court proceedings, this can take in excess of 3 years, and I'm being generous around that number. It usually takes a lot longer than 3 years to resolve appeal processes, judicial review processes. And then coupled with this, administrative delays in taking decisions around permitting, are all areas that is a particular area that can be avoided, because it stalls projects combined with the appeal processes and judicial review processes. This all results in a stalling of processes. And that level of inactivity caused by things within your control, such as administrative decision-making timelines, and things out of your control, such as appeals and judicial review processes, it actually causes this inactivity or sterilization impact, which is what government seeks to avoid. So there's a mutually beneficial interest here in ensuring that, disputes relating to the environmental permit processes are resolved in an efficient manner, an effective manner, and essentially a different manner, looking at that 3-year plus timeline when you are in a dispute scenario. And simply put, the current judicial system, again looking at this from a South Africa perspective, isn't able to tolerate an industry such as the upstream oil and gas industry, which is time sensitive and which has legislative regimes focused around getting the investor to do a certain amount of work in a certain amount of time. So it does require some innovative thinking and solutions on our part. I'd like to think that this is a work in progress, and government is thinking about this key area. We certainly have models for the establishment of specialized courts and forums and special rules around urgency. We've yet to invoke those and develop those within the context of the industry. But there's absolutely no reason that these shouldn't be explored in order to avoid the sterilization of the resource.
Absolutely, thank you, Megan. And maybe picking up on that, so there's obviously been some recent changes with the Upstream Petroleum Resource Development Bill being signed into law. So Bongani, come back to you for this very specific South African example. Can you comment on what you think the UPRD, now A, means for exploration in South Africa?
I guess first let's just acknowledge that the Act, the President has assented to the Upstream Petroleum Resources Development Act this end of October, 25th October, and the Act will become effective once the related regulations have been promulgated, among others. So the Upstream Petroleum Resources Development Act separates the regulation of petroleum from hard rock minerals, which is quite crucial to enable the appropriate regulation of oil and gas exploration and production in the country. This is also important given the fluid nature of petroleum, its capital intensity, the associated and inherent risks that may not be found with hard rock minerals. So unlike the current or the Mineral and Petroleum Resources Development Act, which provides for exploration and production rights separately, the UPRDA integrates the petroleum right, meaning once you are issued with your exploration right runs through all the way to a production right. So if it was 9 years currently plus 30 years, you have that security of tenure in terms of your petroleum right. Of course, the Act provides for the orderly and sustainable development of oil and gas now, and it provides for a controlled application system. For example, we should soon after it comes into effect go on to a licensing round, which is a much more controlled licensing system. Thank you.
Great, thank you, Bongani. Conscious of time, and I think with our remaining little while, so I've got one further question for the group, just to wrap up on some of the key challenges, and then I'll open it up to the floor. So Sue, I'll come back to you if I may. So really, just to bring together, to summarise maybe some of what you see as the main challenges in relation to HSSE permitting specifically, and consultation that you face with some of your clients, some of the operators here, and what you think can be done to overcome some of these challenges.
Yeah, I think we mentioned many of the points, and I'm going to make
Yes.
it very short. One could also turn it around and saying the key enablers of a successful processes and engagement, in my mind, are policy clarity and alignment. So it's clear what does the country want, because you cannot assess that on a project-specific level in an EIA process. That is more around the localization and conceptualization of the project. So what's the overall policy alignment and direction? Clear regulatory requirements. We had, I think Megan talked to that earlier. What is required to meet the standards of the country in terms of an EIA process? They can be exceeded, but what is necessary, that there are no challenges afterwards on procedural grounds. Efficient decision making and certainty of process timelines. Again, these are very complex processes, permitting processes, many wheels that are turning at the same time, and there needs to be a certain amount of predictability in order to run this process effectively through its course. One needs to have the access and understanding of communities. So that's often, especially in the African context, communities can be very remote. It might be hard to access them. There might be risks associated in accessing communities. So that is obviously very important to ensure effective communication and engagement. Local content requirements vary across the continent, and we just had a session here before this one indicating how important local content is. How is that applied at an EIA stage, and are the local skills available? I think we had, I heard the tail end of the discussion in relation to steel pipes, for example, so the same applies obviously to permitting skills and availabilities. And then, of course, I guess one point to note is that an EIA process by nature may bring up unexpected issues around a specific project that might require a more in-depth engagement with communities or specialists, and there needs to be a certain provision for that in the project timeline to address those if they arise.
Contingency, if you will, for those things that may come up during the analysis process. Megan, do you have any comments on this at all?
Just want to add to that. There's multiple permitting processes which arise during, let's take a drilling campaign, for example. Both South Africa and Namibia, you're going to be engaging with at least 12 government agencies, from Ministry of Mines to, from the Namibia perspective, to the Revenue Authority, to Customs, to the Minister of Transport or the Ministry of Transport, Ministry of Home Affairs. It is too convoluted and unnecessary. Streamlining those processes into a one-stop permitting shop is beneficial not only from a governance perspective, but also for the investor. So what that will do is reduce delays, you minimize redundancy and conflicting requirements, and you also increase accountability. So from a governance perspective, it seems to make the most logical sense, but yet multiple agencies is still the model in most jurisdictions. So I would certainly hope to see an easier navigation across an easier set or rule book, playbook, making it easier for the investor to navigate and also ensuring that we have consistent decisions being made by various governmental authorities relevant to the industry. Intergovernment coordination is not always present during this permitting process, and it often governments come across as contradictory, too convoluted in their processes. So there is a way to resolve this, and I would hope to see that come through in some of the changes we see happening in these jurisdictions around permitting.
Thank you, Megan, much appreciated. I've been warned about time, so what I would like to suggest, if there's one burning question from the audience, it'd be great to take it. It looks like there's multiple burning questions.
Hi. Yeah, I'll be quick.
You were lucky being at the front.
Excellent. Yeah. Energeo, right? That's the name of your entity? Energeo?
Yes, that's correct.
Okay. Are you in Nigeria?
Say that again.
Are you in West Africa?
The organisation is based in Houston, but we're active globally on behalf of members, basically. So we engage with stakeholders wherever our members require some input, or often we have engagements with governments in particular, different stakeholders, in order to provide some education, as we've touched on different topics. So it varies. We don't have a base here, but we are very active.
Okay. Because based on what you say you do, I think you should have a leg in Nigeria specifically, so that all these interfaces for the various regulatory bodies, you can help us. Lastly, you said you are focused on exploration, right?
Yes, correct.
So what about the development phase and the operational phase? That could be like 30, 40 years down the line. So why you just restricted yourself to exploration?
Our focus as an association is very much on the early exploration phase, so everything up to the point of drilling, basically. For anything after that, there are, of course, other associations very similar to ours, so the International Association of Oil and Gas Producers, for example, or more local players such as Sayoga here in South Africa. So we liaise quite closely with organisations like that to understand more of the life cycle and to coordinate messages around that.
Okay, thank you. I have...
From the front.
Yeah, I have two quick questions. Okay, my name is Ahmed Bashir. I work for Nigerian Content Development and Monitoring Board in Nigeria and CDMB. So the first question is, I've heard, I don't know who's going to take it, but I've heard a lot about the delays in getting permits in South Africa and Namibia, some instances mentioned. I don't know if the regulator is going to take that. So in Nigeria, we've had that challenge, and there's a drive now to have hold regulators to certain approval days, include with clauses of default approvals. I don't know, how do you handle it from your own end when the permit is taking so long and the regulator hasn't responded to the operating company? That's the first question. Then the second question I have, I've heard a lot about the community consultation as regards the environment, really. I don't know, in these consultations and approvals, is there somewhere it's embedded regarding how to onboard the community into the exploration activities in terms of third-party services or co? Do you have something like that? How do you work it during your consultations with them? Thank you.
Thank you for the question. I'm going to look to colleagues for some potential support here. No?
I'm happy to take I love those provisions. If you haven't approved within 30 days, it's deemed you have approved, right? That gets us to the expeditious decision making, which is really required for the industry to thrive and for government to ensure that it gets its work program delivered. So there are not many jurisdictions that I'm aware of that actually have those provisions. Generally, you have to wait for the approval. I thought I heard you say a comment about the lazy regulator. That was not at all what, perhaps I misheard. Delay, okay. Yes. So, Bongani, I mean, I think you can talk to the petroleum agency's turnaround and what you've been doing in the regulator's office.
No, in fact, we have prescribed time frames within which we must process applications and renewals and renewal applications. So we try as the Petroleum Agency to really adhere to those prescribed timeframes. So sometimes delays can also come through in the form of the applicants themselves when they don't provide adequate information in support of the application. Then we must send back some of the applications seeking the additional information. So from a regulatory perspective, we do try to adhere to the prescribed timelines, but there needs to be a balance also in terms of an application must contain all the information to ensure the efficient processing thereof. Thanks.
Thank you, Bongani. We'd love to take more questions, but we must hand over to the next panel. So I do appreciate your feedback. If you do have anything more, please come and speak to us afterwards. Just to finish on, the Menti, thank you very much for completing that. And the number one response was environmental activism. So that is the greatest above ground risk. Number two was fiscal terms. So interesting to see that split, if you like, or that ordering. Thank you very much to all of our panelists. Really appreciate you being here today. So as we depart, please a round of applause for everybody on the panel today.